So welcome back, guys, to my YouTube channel. Today on the channel I will be discussing whether or not the Central Bank of Nigeria has the powers to freeze your bank account. Now, so case in point, last week Tuesday, the CBN made an application to a federal high court in Abuja, praying that the court should freeze the bank accounts of Bamboo, Risevest, Trove, and Chaka. And guess what? Federal High Court in Abuja actually granted this ex-parte order. Now, the order wasn't granted for 7 days or for 14 days like any other usual ex-parte order. The order was granted for 180 days. So stay with me as I do the analysis of was it right, was it wrong, what are the powers of the CBN vis-a-vis freezing of accounts, and whether they can freeze your bank account or any third party can freeze your bank account altogether. So here is the analysis. So what provision of the law actually contains the powers of the CBN to freeze accounts? The power of the CBN to freeze accounts is actually contained in section 97 of the Banks and Other Financial Institutions Act, which is also known as the BOFIA 2020. What section 97 actually provides for is that where the central bank governor has reasons to believe that some illegal transaction or criminal offense is being conducted in connection with an account with any bank, specialized bank, or other financial institutions, which will now include fintech companies pursuant to the BOFIA. So the BOFIA has now expanded the meaning of other financial institutions to include payment service providers, and that would include the likes of Paystack and all your other fintechs. But the CBN cannot freeze an account unless after the governor has that reason to believe or suspects that crime is being committed using a bank account. The CBN cannot just give an order to the governor, or I beg your pardon, the manager of a bank or to any bank to freeze your account. The CBN would first of all need to apply to a court, the Federal High Court, and then verifying on oath, meaning it would also swear to an affidavit confirming that is suspicion, so to say. Now, once this is done, that of course, because they would not want to put, if indeed crime was being committed using that bank account, it would be foolish to put you on notice, that is to notify you that they are about to freeze your account, because once that happens, that criminal, so to say, can move all the monies out of the bank account. So that is why the application is usually ex-parte. In law, ex-parte means without the other party. That is, you are making the application without notifying the other party. Courts will consider the application and would grant the order to freeze your bank account. Now, once this order has been granted, the CBN can then make a call to the relevant banks to freeze that particular bank account. Now, here is a twist. So, how long does an ex-parte order usually last for? Rather, an ex-parte order will typically last for 7 days, which can be extended for another 7 days, within which the other party will respond to the order. And where the court finds your response or your defense or your counter argument reasonable or more tenable than what the CBN has given, the court will actually vacate the order, and then you can continue to use your bank account. So usually an ex-parte order would last for 7 days according to the rules of court and can be extended for another 7 days. However, that same Federal High Court rules provides for what the language actually says is that the court may grant the order for 7 days unless it is in the interest of justice. So the judge may exercise his discretionary power to extend the period of the order that is beyond the usual 7 days or 14-day period. So the question for most people is that, so if what is usually 7 or 14 days, how come this particular order was granted for 180 days? That what could be the actual justification for that? So that's the first concern for most people. Well, the only answer that may be provided, right, is that, so if we were attacking this legally, by law, the judge is actually empowered to extend the period for which the order would last for. So legally, the court is empowered to make the order to last for that long. But what you can attack is whether that discretion was then exercised judicially and judiciously, and what in law would justify 180 days. Well, the only justification that I can think of is that if true crime were alleged, for instance money laundering, then the police or the AFCC may in fact need up to 6 months, 180 days, to properly conduct an investigation. But the question is whether the CBN consider the consequence. So we understand that, yes, maybe this is, for the sake of argument, that this is legal. But what about the unintended consequences of freezing the bank accounts of these online trading platforms, that is like the Bamboo, Chaka, Trove, and Risevest? Now recall again that most of these people or these companies have recently just raised capital from foreign investors. What kind of signal is the CBN sending to foreign investors? And in subsequent funding rounds, such a signal is likely to impact the valuation of Nigerian companies, because you must value it lesser than you would ordinarily value because of the risk of losing your investment. So you want to invest less than you would have invested but for uncertain or unpredictable government policies like this one. So these are some of the unintended consequences. So those are some of the sentimental comments and arguments that people have made on the one hand. Now let us attack this legally. Based on the order that was released and the reports, the news report, the grounds that the CBN stated for the application and the grounds upon which the order was granted was that these platforms, one, were purchasing foreign currency, dollars, to execute trades in foreign shares and bonds, contrary to a CBN circular. Circular was issued on the 1st of July 2015. And what does that earlier CBN circular say, right? And I did some digging. Now that CBN circular included new items on what you call not valid for forex lists. So the CBN has a whole list. There are lists of items which he has called eligible items. You want to pay for school fees abroad, credit card transactions, you want to travel, business travel allowance, personal travel allowance. Now these are eligible transactions. You want to import goods, you can take your naira, approach a bank and purchase dollars for the purpose of those eligible transactions by filling the relevant form A, B, and so on, or form M, form A, and so on and so forth. However, there is another list that the CBN has termed or tagged not valid for foreign exchange, meaning that any of the items on that list, you cannot go to a bank to purchase dollars to execute those transactions. Now, one of those items in 2015, purchase of shares and bonds in foreign markets was included on that list. So today, you cannot approach a bank to purchase dollars in order to buy shares in foreign companies. So that was what was contained in that CBN circular, and the CBN prohibited it, and in fact threatened to sanction banks, that is authorized dealers, who help to facilitate this transaction. So the implication of that order that was granted on Tuesday is not only for the fintech companies or whose accounts were actually frozen. The banks as well may likely face some sanctions for facilitating those transactions. So according to reports, most of these platforms, Bamboo, when you buy foreign stocks like Apple and Bamboo with your Naira card, the Naira is what Bamboo uses to buy dollars so that they can settle the shares that you bought in the UK or in the US or wherever, right? Now, remember that this has been marked not valid for effect. So by doing that, what the CBN is saying is that you have been acting contrary to my circulars and therefore you are in breach. Now, the question then is, does contravention of a CBN circular amount to a crime? The answer is no. The Constitution is clear in section 36 of section 12 that for something to constitute a crime, it must be written in law and the punishment for it must be prescribed. So the CBN circular does not create any crime, and contravention of it at best will result in sanctions for the banks regulated by the CBN, but does not lead to a crime. Now, crimes are usually created by statute or by regulations which are made pursuant to a statute. The section which also empowers the CBN to freeze account, which is section 97, also says any criminal offense in accordance with any law. It doesn't say in accordance with any circular. So obviously, if the only allegations against Bamboo, Chaka and Trove is that they were purchasing foreign currency contrary to a CBN circular, then this does not constitute a crime and therefore cannot be validly brought under the powers of the CBN to freeze account under section 97 of the BOFIA 2020. It's as simple as that. The other allegation is that Risevest has been using monies in his bank account to purchase cryptocurrency. Again, in February of this year, the CBN also released a guideline saying that no bank should facilitate cryptocurrency transaction, and anyone using their bank account to facilitate cryptocurrency transaction should have such an account closed down. So when you close the account, you refund all the monies in the account to that person. The person can no longer, deal with the bank, cannot use the banking system. That circular does not in any way say that whoever uses the account to purchase cryptocurrency should have their account frozen, because freezing of an account must be for one because such an account is being used for a crime. That circular says the account should be closed down and not to be frozen. So one struggles to understand on the basis of which CBN has based this application. Then the third argument that was made is that they were operating without a license as an asset management company. Now, the person who determines what license a capital market operator should have is not the CBN. The regulator for securities in Nigeria is the Securities and Exchange Commission. And that commission has recently come out with a new licensing category for the likes of Bamboo, Chaka, Trove, and Risevest, and it has called it the digital sub-broker license. And I know for a fact that Chaka is the first of the four to obtain this license. So one struggles to see where the CBN is coming from with respect to license. There is an opportunity for Chaka, Trove, and the affected online investment and trading platforms to appear in court, and the court actually noted that in the order. that this is not absolute, that there is still a chance for the affected parties to now come to court with the CBN and argue their case. And if the court agrees with Chaka and Co., then the order will be vacated. So that is analysis of what happened. So generally, can a third party also freeze your bank account? A third party cannot write to your bank asking your bank to place a restriction on your account. The law doesn't also permit that, right? What the law, and since the Bofia 2020, banks have also been careful. So banks, since the enactment of the Bofia, now require you, if you suspect that you have transferred money to a fraud and you want to have that account restricted, they will require that you approach a court to get an order to freeze that account. So because when the failure of the bank to obtain or to see that order of the court, ordering the bank to freeze the account, is that, one, there is no privity of contract between you and the bank. The only contract that exists, the banking relationship, is between that bank and the alleged fraudster. So the bank only has a duty to that fraudster, except it is based on an order of court. So you cannot freeze an account of a customer without first obtaining an order of court. And there's case law, there's Nigerian case law on this point, where the bank restricted an account without obtaining the order of court. First of all, the customer simply sued the bank, right, for blocking his account without his express consent or without obtaining an order of court. So that is why the banks have been careful nowadays. So when immediately you transfer money to a fraudster, yes, notify your bank, and your bank should also notify the other bank so that investigation can begin. Then as an additional step, you need to immediately engage a lawyer so that an application can be filed, and then you can obtain an order sent to the fraudster's bank, the alleged fraudster's bank, so that the account can be frozen immediately. So these are some of the intricacies, and you know that a bank should not just unilaterally place a restriction on your account unless an order of court is obtained. So going forward, I am going to be doing a breaking it down series. So let me know in the comment section what legal issues that you want me to break down. And recall, you see that I have broken it down because I am assuming that not only lawyers are listening to this or watching this. So just let me know any legal concept, and then I'll break it down to you, like your toddlers. So I really enjoy doing this, and see you guys in the next video.